Welcome, welcome, welcome. This is going to be intense, so just get ready. So I have about an hour and a few minutes to talk about the religion clauses. This will be a very crash course, if you will, on the First Amendment, establishment and free speech. I'll do establishment first and free exercise second. Okay. All right, so the First Amendment begins, Congress shall make no law respecting establishment of religion. This is the Establishment Clause. When the Establishment Clause was first ratified in 1791, several states had established, that is, official churches. And some of these churches retained their status until the middle of the 19th century. Today, the Establishment Clause is often associated with this concept of the separation of church and state. Yet, as I'm sure you all know, this phrase appears nowhere in the Constitution. Instead, it comes from a letter that Thomas Jefferson wrote in 1802. I want to give you sort of a survey of Establishment Clause cases. We will start with a case called Everson versus Board of Education. Then we will do a case called Engel versus Vitale from 1962. Then we're going to jump ahead a bit to Marsh versus Chambers. Then jump ahead more to Town of Greece versus Galloway. We'll do a couple cases from the Rehnquist Court, Mccreary County versus Kentucky versus ACLU, Van Orden versus Perry, and most recently American Legion versus American Human Association. This is just Establishment Clause. We'll see how far we get. I think I can do them all. All right. The Supreme Court's modern approach to the Establishment Clause began in 1947 with Everson versus Board of Education of Ewing Township, New Jersey. Everything always starts in New Jersey, right? At the time, I'm from Staten Island. At the time, some parents in New Jersey sent their children to Catholic school on public buses. And the government had a policy to reimburse these parents for their bus fare. Okay, seems reasonable. A taxpayer challenged this policy. He argued that spending money on students and in religious schools was an Establishment Clause violation. The court upheld the policy, but they did something else. Justice Black wrote the opinion. And he said we're going to ground our approach to the Establishment Clause in this famous letter that Jefferson wrote in 1802. I'll just read you this passage. Jefferson wrote, "Believing with you that religion is a matter which lies solely between man and his God, that he owes account to none other for his faith or his worship, that the legislative powers of the government reach actions only and not opinions, I contemplate with sovereign reverence the act of the whole American people, which declared that the legislature should make no law respecting and establishing religion, or prohibiting the free exercise thereof, comma," becomes the important part, "thus building a wall of separation between church and state." It's not entirely clear what Jefferson meant, and he is not the only source of authority in the First Amendment to boot. But the court adopted, at least purported to adopt, Jefferson's approach. Justice Black wrote, "The First Amendment has erected a wall between church and state. The wall must be kept high and impregnable. We could not approve the slightest breach." Yet the New Jersey law did not breach that wall, so Everson upheld the Jersey policy. But 15 years later, we return to this phrase, church and state separation, in Engel versus Vitale, 1962. At the time, if you can believe it, in New York City public schools allowed prayer. You do the Pledge of Allegiance, and then they would say a prayer. I'll read it to you. It says, "Almighty God, we acknowledge our dependence upon Thee, and we beg Thy blessings upon us, our parents, our teachers, and our country." My mom was actually a student in New York City public schools. She remembers doing this, at least before this case, in her earlier years. And students were not required to remain in the room for prayer. They could be silent or be excused. A number of parents challenged, in fact, the lead plaintiff, Engel, was a Jew, and they challenged this policy. The Supreme Court ruled in favor of the parent by 6-1 vote, and again, Justice Black wrote the majority opinion. Justice Stewart wrote the lone dissent. And the majority and dissent disagreed on 4 primary issues. First, the court held that the prayer breaches the constitutional wall of separation between church and state. Justice Black wrote, "The government cannot compose official prayers for any group of the American people to recite as a part of a religious program carried on by the government." New York's policy, the court ruled, officially establishes the religious beliefs embodied in the prayer. Justice Stewart said, no. There is no wall of separation. Letting those who want to say the prayer say it is not an establishment of religion. Second, they turned to history. And Justice Black said that many colonists left England and sought religious freedom in the United States in response to governmentally composed prayer. Under the First Amendment, Black explained, the power and prestige of government cannot be used to control, support, or influence the kind of prayers that the American people say. Justice Stewart viewed the history very differently. He found that the New York policy was supported by history and tradition. There was a long-standing tradition of prayer in American institutions. Even the Supreme Court, if you ever go, they begin every session with God Save the United States and this honorable court. The Marshal of the Supreme Court is investigating this monster leak. Her only real job is actually to announce the court's opening. Presidents from Washington to the president said, "So help me God," at the end of every inaugural oath. The Pledge of Allegiance says, "One nation under God. In God we trust" is the motto. It's not "E pluribus unum," it's "In God we trust." Don't forget that part. This history, Stewart says, provides a strong foundation for New York's policy. Then came the issue of pressure and coercion. A number of the justices in the majority thought this policy was coercive. And Chief Justice Warren asked this question during the argument. So imagine a lawyer goes to the Supreme Court to present an argument. And before the case begins, the Chief Justice instructs everyone, "All right, everyone, let's say a prayer." Would any lawyer sit down during that session? Would they feel perhaps retaliation if they were to sit down and excuse themselves for their prayer? Then Warren says for children, it's even worse, because there will be contempt and ridicule for children who do not participate in the prayer. Right? Justice Stewart said there's no compulsion. We have West Virginia versus Barnett. You cannot be required to say the Pledge of Allegiance. By the way, the Pledge of Allegiance back then was like this. It was basically a Hitler salute, right? You would raise your right hand and salute the flag. It wasn't like this. It was like this. We changed one after the war. Okay. And the majority of the dissent also disagreed about the relationship between the Establishment Clause and the Free Exercise Clause. Justice Black wrote that the founding generation knew there was a great danger, that one of the greatest dangers to worship is when the government places its stamp of approval on one kind of prayer. Justice Stewart disagreed. He said, denying the wish of these students to pray denies them their free exercise rights. We don't think of this, but you have a right to pray. And they're saying to students, you cannot even do this, even if you so choose. All right? So the rule in Engel versus Vitale stands to this day. Public schools cannot begin classes with prayer. And there were a number of cases of extended Engel's holding. One, Abingdon School District versus Schempp, 1963, held that teachers cannot recite passages of the Lord's Prayer. Students came and hear it. Stone versus Graham, 1980, held that classrooms cannot post a copy of the Ten Commandments on the wall. Courts said those are plainly religious in nature. Wallace versus Jaffrey, 1985, held that public schools cannot hold a moment of silence for prayer and meditation. Lee versus Weissman, 1992, held that clergy, actually a rabbi, could not offer prayers at a high school graduation ceremony. This is Rabbi Leslie Gutterman from Rhode Island. Who's from Rhode Island? One of you. You know Rabbi Gutterman? Anyway, Rabbi Gutterman is the Rabbi Emeritus, one of the synagogues in, I think, Providence. But anyway, this was at a high school in Rhode Island somewhere. Santa Fe Independent School District versus Doe, 2000, held that schools cannot permit students to lead prayers at school. But there's a case pending as we speak. Coach Kennedy versus Bremerton School District. This was a football coach who wanted to pray at the 50-yard line by himself quietly, and the Ninth Circuit ruled against him many times. We'll see what the Supreme Court does any day now. We'll see. Okay. Next, let's jump from prayer in school to prayer in government institutions. Marsh v. Chambers, 1983. You may know this, Nebraska has a unicameral legislature, only one house, and they have one chaplain who would deliver a prayer before sessions began. He was a chaplain employed by the state. He was a Christian chaplain who did all the prayers. Was this practice valid? The Supreme Court upheld the prayer before the legislative session. And here we have an opinion by Chief Justice Warren Burger. And his opinion was very historical in nature. And Warren recalled that since the founding, American institutions have began their sessions with prayer. In 1774, the Continental Congress adopted the practice of opening with a paid chaplain. In 1789, the same Congress proposed the First Amendment, authorized salaries for chaplains in the House and in the Senate. And for more than 2 centuries, the House and Senate begin their sessions with prayer. And the Supreme Court, of course, says, God save the United States and this honorable court. Indeed, most state legislatures follow this practice, and they have a designated chaplain. The court found there's an unambiguous and unbroken history of more than 200 years. So the court upheld the prayer before the legislative session. The next case in the genre comes from 2014, Town of Greece versus Galloway. Town of Greece is in upstate New York. I've never been there. I've never been there. And the town board had a meeting every month. At these meetings, residents can make requests of their government, they can complain, they can do all these various things. At the beginning of each meeting, the town supervisor would invite a local clergy member to lead a prayer. The process was somewhat weird. They basically flip through the phone book and say, aha, we got a priest, we got this, we got that. Based on the location, almost everyone they had was Christian. They eventually had like a Wiccan and some other ones, but virtually everyone was Christian. I don't know why they're a Wiccan, but what's a Wiccan prayer? How would you know? I don't know. I don't want to get myself in trouble. I don't know. Okay. Susan Galloway, a resident of Greece, argued that the prayer policy violated the Establishment Clause. Who, by the way, was Jewish. No same pattern. Engel, the plaintiff, was Jewish. Galloway was Jewish. Anyway, that's where we are. That's where we are. The Supreme Court ruled for the town of Greece by a 5-4 vote, and this was actually one of Justice Kennedy's last big opinions. And there were 5 parts of the opinion. First, there was a lot of discussion of how the clergy were selected. Basically, they would go through the phone book and just pick whoever was available. So the Greece policy differed than from Marsh v. Chambers. In Marsh, was one paid chaplain who was doing it full time. Here, there was a rotating cadre of clergy that came around. But unsurprisingly, they were almost all Christian. There was a Wiccan somewhere along the lines. A lot of discussion also happened on the nature of the prayer. And this is something that I think we're probably more attuned to than otherwise. You can do a prayer that says God, or you can do a prayer that says Jesus. Is there a difference? Because a Heavenly Father, our Lord, or the Father, the Son, the Holy Spirit. Right? There's different words you can use. You can talk about sort of general themes like peace and harmony and goodness in the world, or you can say He died for our sins and He will we draw strength from His resurrection. The majority said that most of the prayers delivered were sort of non-sectarian, but there were some prayers that spoke about resurrection and drawing strength from the cross and other sorts of things. Just because some of the prayers had specific references to Christianity did not render the policy unconstitutional, right? For an important reason. What would happen if the government instructed priests of what they could and could not say, right? Could a town supervisor tell a priest, you cannot say Jesus? You cannot refer to the resurrection? That would, I think, have serious free exercise problems as well. So it's sort of this weird balance where it's like, we're inviting you, we can't tell you what to say, but we want you to say X, Y, and Z. So I think the court was not willing to go down the road of instructing priests what to say. There are some governments, that maybe David knows about this, where they actually give kind of guidance about what kinds of prayers are acceptable. They do have these manuals. Doug Laycock, a professor at UT, argued this. He's like, everyone knows the difference between basically a good prayer and a bad prayer, right? And he was actually pretty clear on this.
It's like pornography.
Yeah, you know it when you hear it, I suppose. The court said the mere fact that it had some religious overtones of Christ's resurrection did not render it unconstitutional. But the court said some prayers may be too bad. They may cross the line. For example, you cannot, I'm going to quote this one, you cannot denigrate non-believers or, is a quote, threaten damnation, okay, or preach conversion. So I suppose you can't say, you're going to hell, right? You can't do that. You're going to burn, right? You can't do that. But apparently Justice Kennedy thought there's some things you can't say. Kennedy wrote, "Those prayers will fall short of the desire to elevate the occasion and unite lawmakers in a common effort, because you're all going to hell." Right? Remember the church lady from Saturday Night Live? Satan. Right? Remember that? Oh no, I'm dating myself. How you know what I'm talking about?
Everybody watched Saturday Night Live.
Dana Carvey. Oh god, I'm in the wrong. I'm in the wrong one. He knows. Okay. Then they turn to the topic of coercion, which is actually significant. Susan Galloway was actually interviewed on C-SPAN. I watched it. She said that when she goes to this meeting, everyone's standing up and she's sitting down, and that puts pressure on you, right? If you're the only one in the room sitting during a prayer, that puts pressure on you. It singles you out. Most people feel pressure to sort of bow their heads and quiet, and Susan Galloway did not. The court basically said, yeah, you're going to feel some offense. It's going to be pressure. That doesn't make it unconstitutional. And this moves away from the so-called coercion test, which the court has adopted in the past, like in the Rhode Island high school case. So apparently for children, coercion is a problem. For adults, just suck it up and deal with it. That might be the rule we can draw from that.
Real coercion.
Oh, of course, psychological. No one's actually forcing you to stand there, right? They're not locking the door, padlocking the doors, and chaining you to the seat. All right. Justice Kagan, who, by the way, now is the only Jewish justice because Ginsburg's gone and Breyer will be gone any minute now. So we're down to one. One is right. We got one left. She wrote the dissent, and she said that Marsh was different because the prayers in Marsh were given in the Judeo-Christian tradition, but the town of Greece prayers were explicitly Christian. That's what the difference is, right? But without question, the Greece prayers were more religious and less inclusive. And she thought that everything about this is unconstitutional. All right. But with the town of Greece case, we're seeing a shift from the sort of Warren Court, big separation wall, got to keep everything separate, to like, well, let's look at history and, this is not so bad, and the atheist might be offended, right? The next case was a very big shift, which is American Legion versus American Humanist Association. Anyone from Maryland here? You know where Bladensburg, Maryland is? No, okay. Bladensburg, Maryland, I don't even know where it is, but it's somewhere in Maryland, and they have a cross, a 30-foot tall cross in the middle of a highway. All right, let's talk about it. Let's go back a little bit further, though. Anyone ever been to Austin, Texas, the capital? Oh, you guys got to come. All right. So if you go to the Texas Supreme Court, immediately outside the Texas Supreme Court is this ginormous 6-foot-tall stone statue of the Ten Commandments. It's still there, despite the hopes of many people trying to get rid of it, right? So about 20 years ago, there was a homeless guy who was walking past it and said, "I'm offended by this," and he actually filed a lawsuit. I'm not exaggerating. It was Van Orden versus Perry. Who the heck is Van Orden? He was basically an itinerant guy who liked to do research at the law library at the Supreme Court of Texas. He saw it as, I'm filing a lawsuit. And he wants to demolish the statue of the Ten Commandments. Okay. Then you have Mccreary County, Kentucky. This was a very conservative town who said, I have an idea. Let's put up a display of the Ten Commandments in our courthouses. Okay, they got sued. They said, I got an idea. Let's double down, make it even worse. So they put another display of the Ten Commandments, and they highlighted all the religious references in the Ten Commandments, right? Okay, they got sued again, even worse. Then they finally got some legal counsel that was competent, and they put a third version of the display. And this was the Ten Commandments, but also the Bill of Rights, Lady Justice, the Star-Spangled Banner. David, was this your term, 2003? No, you were...
2002.
But this was 2005, okay.
A couple terms later.
Yeah, that's a couple terms later. Okay, I was trying to do the math in my head. Yeah. All right, so you have these two displays of the Ten Commandments. There's this 6-foot-tall granite monument in Austin, and these, these little paper displays in Mccreary County. The Supreme Court splits the difference. They say the Texas monument can stay, but the Kentucky monument has to go. Why? Ask Justice Breyer. I'll get to Breyer in a minute, but the majority opinion from Justice Souter said the Kentucky monument has to go. It has what's called a legislative purpose. This is part of the so-called Lemon Test, right? They see, does some law have a secular purpose or a religious purpose? If it does, it's unconstitutional. But the Ten Commandments monument in Texas could stay. Why? Breyer seemed very concerned to this day that demolishing monuments might be divisive for society. That if Christians see a Ten Commandments monument being torn down, they'll express antagonism towards Christianity. He's like, well, it's been there for a long time. No one's objected. Let it stay. It's not bothering. Let it be there. The one from Kentucky is sort of new. So we got to get rid of it. So this is the rule: if something weighs more than 2,000 pounds, it's constitutional. If it's less than 2,000 pounds, unconstitutional. That's your Breyer test for the Establishment Clause, only slightly exaggerating. But that matters for the more recent case, the American Legion case. After World War I, cemeteries were built across the United States and in Europe. And you have this image of these plain white crosses, fields and fields. You read the Field of Flanders, right? These white crosses. If you ever actually go to the Field of Flanders, they actually have the Stars of David. They actually have a number of them. Oh, it's a detour. I didn't know this, but during World War II, a number of Jewish soldiers would not put on their dog tags they were Jewish. Why? They were afraid if the Nazis captured them, they would be killed. So there were actually a lot of Jewish POWs who were murdered, who were buried under crosses because they had Christian on their dog tags. There's actually a group now going back and basically, there's a word, but reburying them with Stars of David on their tombstones. It was in the New York Times like last week. I'm not joking you. They literally said, "Wow, Joey Gallowitz, that sounds like a Jewish name." They're literally just checking names, see if they sound Jewish because they have no idea and they're tracking down their families. So this is actually relevant to this case here. But there were these images throughout Europe of these white crosses as a symbol of those who were lost in the First World War. And in 1918, people in Prince George County, Maryland, formed a committee to build some memorial for the fallen soldiers. They decided to build a 30-foot tall Latin cross. I mean, this is just ginormous. And they put it in the middle of a highway. It's like a pawn shop. It's completely random, right? But there's a ginormous cross in the middle of this area to celebrate the 50-some-odd soldiers who gave their lives in the First World War. The American Humanist Association does what they always do. They sue, and they challenge the cross as a violation of the Establishment Clause. What was the remedy they seek? They wanted the cross to be removed, demolished, I'm not joking on this last one, or to amputate the arms. That is to turn the cross into an obelisk. I swear I'm not joking. A judge on the Fourth Circuit, how am I joking?
You're not joking.
A judge in the Fourth Circuit actually proposed a remedy: leave the cross in place, remove the arms, becomes an obelisk. I swear, if it's in the record. You can pull this up. I'm not joking. And by the way, you can't move this thing. It's a 32-foot stone structure. It would crumble. If you tried to move it, it would break. You can't transport it anyway. So it's actually in very bad shape. See if you repair it. But anyway, you can't move it. The court upheld the display by a 7-2 vote. But the majority opinion was very, very, very fragmented. In total, there were 7 opinions written. 7. So Justice Alito wrote a majority that was something of a plurality. Your concurrences from Breyer, Kavanaugh, Kagan, Thomas, Gorsuch. Excuse me. Then you had Sotomayor and Ginsburg have a dissent. So you have 7 opinions for 9 judges. Like 2 Jews, 3 opinions. This was a very fragmented case. We see everyone wrote but the chief and Sotomayor. All right. So there are 4 primary issues in this case that I want to talk about. What role does history and tradition play? All the judges agree that history and tradition must play some role, and Town of Greece supports this. But they didn't agree what role history and tradition should play. Justice Alito wrote a plurality that was joined by the Chief Justice and Kavanaugh. And he wrote, quote, there should be a presumption of constitutionality for longstanding monuments, symbols, and practices. In other words, if it's been there for a long time, it's probably okay. That's not very reassuring. Gorsuch and Thomas said this is insane. What difference does it make if it's been there for a long time? The Constitution's fixed, right? If some atheist brought this challenge in 1919, would it suddenly be unconstitutional because it has been there for a long time? So the reason why there was no majority is that Gorsuch and Thomas wouldn't join the sort of, pardon the French, virtue signaling from the plurality, saying, well, we're just not going to rock the boat. Now, why did Alito go along with this? I think to keep a majority of some sort, right? Because Breyer joined that part of the opinion. So I think they wanted to have the appearance of the liberals joining, see, we're all in agreement, right? But they're actually making an opinion that's meaningful elsewhere. Breyer specifically said, history and tradition is nice, but we have to look at context and its other sorts of things. So we don't have a 5-member majority in what the rule actually is, other than if it's really old, it's probably okay. New memorials don't work. So for example, this after 9/11 at Ground Zero, there was a cross that basically formed naturally, right? Just by when the buildings came down, there was a cross in the steel beams. And there was actually litigation in the Second Circuit, right? So what if by act of terrorism, I suppose, a cross forms. Can you keep that cross? And they kind of danced around that question. But there was actually litigation to take down that cross as well. I don't know. Whatever. All right. Then the court divided about the meaning of this cross. Now, I think we all agree a cross is a Christian symbol. I think we just go across the hall. There are probably thousands of them in that room, right? It's a Christian symbol, right? It represents the Christian faith in all its regards. But that's not enough, because the court said, in the wake of World War I, the cross adopted an independent secular meaning. Was that?
Like Christmas trees.
I don't know if that's right, but sure, right? Not you're saying, but the idea that it's a secular meaning, I'm not sure.
Because of the grave.
Right, because of all the gravestones in Europe, this became a very symbol. Now,
Allegheny County case?
what's that?
Like Allegheny County.
Yeah, like this, the Christmas tree is not really Christian, I suppose. It's whatever, right?
Phone is bad for them.
Yeah, right. I mean, that's part of the thing. It basically it secularizes the cross. And there were actually, I think there was a Baptist group that put an amicus brief saying, don't rule for Maryland on these grounds because it diminishes the value of the cross to say it's a secular symbol.
Christ and Christmas.
Yeah, but yeah, this is the Horn Christmas of the Supreme Court, right? But the court went along with this. And Ginsburg disagreed, saying a cross is Christian. And there are Jewish stars in these cemeteries. If you go to the cemeteries of World War I, you'll see Jewish stars every now and then. Not a lot of them, but they do exist. Another issue was, were there actually any Jewish soldiers from Prince George's County who died and who were disrespected by this? So in other words, you're honoring a Jewish soldier by a cross. And Alito sort of danced around this issue. He says, well, there's no record there are any Jewish soldiers from this area were excluded. And this is my favorite part. There's no evidence that any Jewish soldier's name was placed in the memorial against the wishes of his family. So, his mother didn't object, I suppose. In fact, one of the persons fundraising for this cross was actually a Jew. So, whatever that's worth. The court also talked about the Lemon Test. This is this 3-part test from Lemon versus Kurtzman that looks at the purpose of a law, the effects of the law, whether it's entanglement between church and state. And the court basically says, well, we don't like Lemon. We're not going to apply it here. We're not going to overrule it. And Breyer's like, no, we're not overruling it. So again, for the price of Justice Breyer's vote, we have an incoherent opinion, which is basically how I see this case. It's unfortunate. I would just say, Breyer, adios. You're going to leave anyway. We didn't know this then, but it's who cares, right? But the opinion doesn't tell us much. Kavanaugh's like, well, we're not going to overrule Lemon. We just won't apply it anywhere else. We'll just stop applying. We'll pretend. But the problem is the lower courts apply it, right? The lower court in this case applied Lemon, even though the court hasn't used it in 30-something years. Justice Thomas said, overrule it, get rid of it, I'm with CT, right? I'm right. Okay. Now, the last part was actually widely agreed. They said demolishing the peace cross would send a message of hostility to people of faith. Justice Breyer had expressed his concern in the Ten Commandments case, and he said, look, we don't want to be tearing down historical monuments. Although I wonder what Breyer was thinking about all the Confederate statues that were basically being torn down in the dark of night.
But they're not. That's not a religious symbol.
I don't know. We'll leave it there. Ginsburg said, well, maybe you can move it or transfer ownership. The problem was that transferring ownership was it was a highway, and you couldn't transfer a highway possession to a private group, and you can't move a 32-foot tall stone cross. It would crumble. It's not feasible. Anyway, so that was the end. The court said this does not offend anyone. The court says this might offend people, but it doesn't offend the Constitution. Gorsuch was very, just a total aside, why is there standing in this case? Why do you have standing by being offended? Oh my God, I wrote this a couple years ago, I got in trouble. But I was like, just being offended by an established clause violation is not an injury for Article 3. I don't think any of these cases. Why is that a homeless guy walking past a statue gives him standing?
We've written this a whole number of times.
I've gotten in trouble. By the way, so we talked before, one reason why I would never get hired today, I say these things in public, and I get in trouble, but I don't care if tenure. They both, we have tenure, it doesn't matter what they think. Okay.
Has the standing question never been argued, or?
Gorsuch
flagged it. Gorsuch flagged it in this case, and it just got one or two votes.
So let me know. I have a question about this issue we're talking about.
I got 30 minutes more. I got to do questions later. All right. All right. That's an establishment clause. Let's do free exercise. See, I'm right on schedule. I said 45 minutes, 30 minutes. I'm right on schedule. Okay. Free exercise clause. I want to do 4 or 5 cases, depending on how much time I have. So we'll do Sherbert versus Werner, Wisconsin versus Yoder, Employment Division versus Smith, Church of Lukumi Babalu I versus City of Hialeah, and Fulton, if I can fit, I think I can do it. So let's start with Sherbert versus Werner. Adele Sherbert was a Seventh-day Adventist. She, like us, celebrates her Sabbath on the Saturday. We have so much in common, right? She was assigned to work on the Saturday, her Sabbath, but she declined that assignment because of religious beliefs. And then she was denied unemployment compensation because she would not be willing to work on that day. This was a challenge to that denial of benefits on free exercise grounds. The court ruled for Adele Sherbert by 7-2 vote. Justice Brennan wrote the majority opinion. Brennan said that the state's actions imposed a burden on the free exercise of religion and put pressure on her to forego her religious beliefs to receive unemployment benefits. All right, so there's a burden. I call it a substantial burden. All right. The next part, the court said that South Carolina did not have a compelling state interest that justified the substantial infringement on her First Amendment rights. Substantial burden, compelling interest, sounds a lot like strict scrutiny, doesn't it? It does. In this case, the court more or less was using strict scrutiny to review burdens on the free exercise of religion. But wait a minute, why are we using strict scrutiny? There's no evidence that the law was targeting Seventh-day Adventists. It was a neutral law. There's no animus. This was not what we call a law of general applicability, applied equally. But we have now what became known as the Sherbert Test, which has two primary parts. So first, if the government imposed a substantial burden on the free exercise of religion, part one. Part two, the state must demonstrate that its law is the least restrictive means to achieve a compelling state interest. This was a very onerous test that was extremely hard to satisfy. If the state interest was not compelling, or if there was another less restrictive means to accomplish the interest, the state can't enforce its law that imposes a burden on the free exercise of religion. Brennan didn't say this explicitly. It became later in other cases what he would always do. Brennan was very good at this. The next case, Wisconsin versus Yoder, is an application of this sort of Sherbert Test. The Amish people, like us, wear black hats. That's where the similarities stop. Sorry, that's bad. I went to law school. I went to college at Penn State, and I once got cut off by a horse and buggy. They're fast. I mean, dude passed me on the left. I couldn't believe it. In the horse and buggy. There we go. Amish people follow a traditional way of life, and under the teaching of the religion, salvation requires life in a church community separate from the world and worldly influence. And to maintain this separation, Amish parents object to sending their kids to public schools after the 8th grade. Wisconsin, however, required compulsory education through the age of 16. 3 Amish parents, including Jonas Yoder, were convicted of violating the state's compulsory education regime. And they were each fined $5. Not a huge fine, but it's a fine. Yoder and the parents challenged their convictions based on the free exercise clause. The Supreme Court ruled for the Yoders by an 8-1 vote. And Chief Justice Berger wrote the majority opinion. He recognized that Wisconsin was not targeting Amish because of their beliefs. It was not animus, as you might call it. This was a law that applied neutrally to all faiths. This is a law we call as generally applicable. Still, under the Sherbert Test, a regulation that's neutral on its face may offend the constitutional requirement of government neutrality if it unduly burdens the free exercise of religion. And then the court considered the 2 prongs of the Sherbert Test. First, the court ruled that the compulsory education law unduly burdens the free exercise of religion of the parents. The parents, right, not just the kids. The values taught in public schools were in marked variance with Amish values in the Amish way of life. Indeed, a high school education could create, quote, serious barriers to integration of a Amish child into the Amish religious community. Chief Justice Berger wrote that a public education contravenes the basic religious tenets and practices of the Amish faith, both as to the parent and the child. And the court said that mandatory schooling after the 8th grade would gravely endanger, if not destroy the free exercise of religion of the parents. This was a substantial burden, easy. Then they go to the compelling interest prong. Berger said the state may have a compelling interest to require younger students to attend primary schools, but the interest is less substantial for children to the age of 16. And only those interests of the highest order can overbalance legitimate claims for exercise of religion. The state's interest in universal compulsory education is not absolute and cannot override the parents' religious freedom. And Wisconsin did not select the least restrictive means. Other states created Amish schools. Go figure, you can do that, right? But the court said we're going to decide what is the least restrictive means. The court recognized that balancing a state's concerns is a sensitive and delicate task. Still, the Sherbert Test was difficult for the government to satisfy, and Wisconsin flunked it. Therefore, the policy was unconstitutional. Justice Douglas, as he often was a lone dissenter. He was kind of like Justice Thomas in reverse, right? He warned the Amish parents from imposing their notions of religious duty upon their children. Children, he observed, have interests.
Sorry, say that again?
You heard me. He warned that Amish parents were imposing their notions of religious duty upon their children.
Yeah.
Yeah, that's what he said. Justice Douglas wanted to ask the children if they wished to follow the parents' belief.
Wow.
I'm serious. Justice Douglas concluded that the state may well be able to override the parents' religiously motivated objections if a mature Amish child wishes to attend high school. The majority opinion imperiled the future of the student, not the future of the parents. So, Justice Douglas, here, ladies and gentlemen, that was Justice Douglas. I believe the children of the future. Teach them well, let them lead the way. Okay. Next up, Employment Division versus Smith. This is a case I'm sure you're all familiar with. The Sherbert Test became unpopular among conservatives. Go figure. They said that the court should not be in the business of balancing social issues. Let the legislature do this. And we get to 1990. Al Smith was a member of the Native American Church. He was a drug counselor. He lost his job because he used peyote, a hallucinogenic cactus, as part of a ritual in his church. He was then denied unemployment benefits because he was discharged for work-related misconduct. The Oregon courts ruled that the Employment Division was required to exempt Smith under the Sherbert standard. This was appealed to the U.S. Supreme Court. The Supreme Court ruled against Smith, and I'm sure you all know Justice Scalia wrote the majority opinion here. Smith didn't expressly overrule Sherbert, but it came pretty darn close. Smith explained that the Free Exercise Clause prevents the government from penalizing adherents to religious positions or the profession of religious beliefs. But an exemption was not warranted here. The court adopted this standard where if a law was neutral and generally applicable, rational basis review would apply. There's no evidence that Oregon was targeting Native Americans. This applied across the board to any use of controlled substance. Therefore, the strict scrutiny standard from Sherbert was not going to be followed. As relevant for us, Justice Scalia acknowledged that this rule would have a disproportionate impact on religious minorities. Right? Because if you're a member of a religious majority, you can use the political process to get accommodations. But if you're a Native American, good luck in the legislature. I think even to the extent Jewish plaintiffs have difficulty seeking these sorts of exemptions. They must come from legislative largesse. Scalia did not want to open up exemptions for every kind of, he did not want to create an exemption for every civic obligation of every conceivable kind. All right. During the arguments, Justice Stevens asked if a state could outlaw the use of alcohol, including wine, in religious ceremonies. And the answer is, under Smith, the answer is probably yeah, you could. If it's a neutral law, not targeting Catholics. Hello. Or Jews. L'chaim, right? But Scalia found this inequity to be the unavoidable consequence of democratic government that must be preferred to a system in which each conscience is a law unto itself, or in which a judge weighs the social importance of all laws against the centrality of religious beliefs. the court refused to create an exemption to a generally applicable law that burdened the free exercise of religion. The government did not need to show that their law was the least restrictive means to achieve a compelling state interest. Smith proved to be very unpopular across the spectrum. If you can imagine, Congress responded with a statute to a case. RFRA, the Religious Freedom Restoration Act, was sponsored by people like Chuck Schumer and Orrin Hatch, right? These people don't usually hang out. Orrin Hatch died a week ago. But, they didn't used to hang out very much. But this was a huge success. RFRA said, we're going back to strict scrutiny, guys. That's what you think. So the Supreme Court in a case called Bernie v. City of Bernie versus Flores said, well, RFRA is valid for the federal government. You can restrict your own stuff, but you can't restrict state government. So as things stand now, if there's a federal law, it's being challenged under the Smith standard. But if it's a state law, if it's federal law, it's under the RFRA standard, Sherbert more or less. If it's a state law, you're back in Smith world. Okay. Now in 93, a couple years later, you have the Church Lakumi Babu Ai versus City of Hialeah. This was an example of where strict scrutiny still governs in a religion case. The Church of Lakumi involved a Santeria case. This is a faith, Afro-Caribbean faith. They do animal sacrifice. To Santeria believers, sacrifice is commanded by the gods, and there's considerable detail how they have to do it. I can show you pictures of it. It makes me very squeamish, but you could Google it. When I was actually making the videos for my Conlo series, I did not put any actual videos of the chicken sacrifice. I was like, it's too much. I didn't want to turn people off. All right. A new Santeria church was planned in the city of Hialeah, Florida. It's not too far from where Fort Lauderdale. It's right near Fort Lauderdale, right, Howie? Yeah. Was that? Yeah. Okay. Oh, it was near Miami? Okay.
It's all the same area.
In the same area. South Florida.
It's just north of
Thank you. So many Floridas. What exit 95? Never mind. Sorry. Okay.
I could probably tell you.
So I'm from Staten Island. In New Jersey, it's like, oh, you're from New Jersey. What exit are you on the Turnpike? Right. That's how you identify your hometown, right? Anyway, a new Santeria church was planned in Hialeah, Florida. Members of the community were very upset because of these animal sacrifices. They we have an idea. Let's pass an ordinance. So they always do. They always pass an ordinance, and they passed a law that more or less banned certain type of killing of animals. Right? You could not kill an animal in a public or private ritual or ceremony, not for use of food. But there were lots of exemptions, right? They exempted people who slaughtered animal for food. They slaughtered people who did it for they exempted hunting, for example, right? So there were all these exemptions, but you couldn't do it for this one context of the animal sacrifice. And actually, Doug Laycock, who argued, interesting guy, he argued in favor of the separation of church and state in the town of Greece case. He argued in favor of the Santeria here and here. So he's a very idiosyncratic guy. I like him. But Laycock argued saying this was about punishing central rituals of this one faith. The court ruled for the church 9-0, and Justice Kennedy wrote the majority opinion. Why was strict scrutiny triggered? This was not a neutral law. This was clearly targeting members of this faith. And how do we know it was targeting? You had all these exemptions. You could go hunting. You could have a restaurant. Do all these other things. You couldn't kill the chickens for this one purpose. It was not generally applicable. It's not neutral. The object was to punish this one religious doctrine. The government said, well, no, it's about public health. The court said, no, you're lying. It's protectional. It's not about public health. And because this was subject to a strict scrutiny, the government was going to lose here. This was not the least restrictive means. I mean, they could have had it, for example, a standard that, if you do sacrifice, you must have certain types of sanitation standards. Maybe you have to dispose of it in a certain way. This comes from the Copper Road context as well. Maybe I'll just take a slight detour because you know about this. There's a Chabad out in California, and every year, they do the Copper Road with the chickens. They swing the chicken, right? This is actually a personal case I worked on. I'm not kidding you. An Erev Rosh, so Copper Road's done. I'm sure if you know about Yom Kippur, right? Around the time. On Erev Rosh Hashanah, this poultry group filed a TRO against a Chabad rabbi to block Copper Road. It's a poultry activist group, animal rights activist. It's not like KFC. Like they advocate for rights of poultry.
Just the animal rights of chicken.
Yes, that's your focus, right? And they basically filed this lawsuit. We know Yom Kippur is coming. It's not like a surprise. It happens every year in the same time, right? They filed a lawsuit Erev Rosh Hashanah. The rabbi was obviously doing other things with life. He ignored it. A judge in L.A., Andre Barati, entered, I'm not joking, an ex parte TRO blocking Kapro because the rabbi defaulted, did not reply to the TRO motion. All right, so I found out about this, and I filed an amicus brief basically overnight, saying that there was no jurisdiction. Why is this even in federal court? Right? Here's the argument for jurisdiction. It was a Maryland company suing a California entity. Okay, got diversity of state, and they said, well, over the course of a decade, there might be $75,000 worth of chicken sold. No. What'd you say? Yeah.
Maybe.
Only if you're really generous with the money that you.
No,
give
but
to charity.
like, so I wrote an amicus brief in like 3 hours.
Chickens themselves, or like the amount that you're giving for the stock option.
It was insane. It was complete speculation. But he said over the course of a decade, like, because the suggested donation was like $18, like it completely made up. So I filed an amicus brief overnight, saying that this is insane. There's no federal question. There's no diversity jurisdiction. This is not belonging in federal court. It's a state issue. And actually, the First Liberty Institute came in and they actually got a hold of the rabbi and they basically represented him. And I think Wilmer, they filed a brief overnight. So the judge held a PI hearing. I'm not kidding you, Erev Yom Kippur. And I'm not joking. I was on the phone as the only Jew on the phone because no one else was willing to do it. And I actually told the rabbi. The rabbi said, "Well, can't you do it like the Reform Jews? Just like put some money over the head of the person." And I was like, "Judge, that's not how it works. You can't. No, you can't." He's like, "Why don't you just do that to chicken? This like chop the arms of the obelisk." So these judges believe, "Oh, can't you just do it some other way, right?" And I was the only Jew. I wasn't even a party. I was just talking. I was presenting arguments. It wasn't even a party. It didn't even matter, right? And this judge. So sundown was going to happen, right? By the time the sundown, the rabbi's got to go. You can't do it anymore. He issued his ruling after sundown, dissolving the TRO. At which point it was already too late, right? The holiday had already concluded. And I was actually sitting in the parking lot waiting to go into shul. And this judge was sitting there just taking his time thinking about a ruling. And I'm thinking about the Lukumi case, like, wow, this is a 9-0 Supreme Court case. And this one judge in L.A. enters an ex parte TRO on Erev Rosh Hashanah to block a rabbi from doing kaparot. And that's one of the reasons I got into this business with Howie, because judges do this stuff. And the LA Times actually published my op-ed criticizing this judge. I can't believe, I think it was a Jewish editor. Right? They published my op-ed saying this judge is an embarrassment.
And the bad guy's brief in that case said, if Smith didn't apply, we would not have, we would lose right away, but Smith exists, so ha ha ha.
But it's the gamesmanship. They deliberately brought the suit right before Rosh Hashanah, knowing the rabbi wouldn't reply. Because they're doing other things. They're doing their business. Anyway, so I was making arguments about Lukumi. I wasn't even a party. I don't know. I was on the phone. I was just like, "Hi, Judge. I'm a Jewish lawyer. Can you just speak?" And I was just kind of, I didn't know what to do because the First Liberty guys are great, but they're not Jews, right? So I had to explain what this was. And there's a nice lawyer in LA who literally filed the amicus brief for me under 1 hour's notice. Like, can you file this now? I was like, yes. And we did it overnight. But when we talked to Jerome about how he can be impactful, this didn't exist before we did it, right? You need to be able to supplement the work that other groups do. All right, let me go back to what we actually had to talk about. All right, so Lukumi was there. All right, I got a few minutes left, and I'll turn it over to David. The most recent case involving the free exercise clause is just about a year ago, which is Fulton versus City of Philadelphia. The facts of this case are very much contested. No one agrees, but I'll just high level. The Catholic Church opposes placing adopted children in gay couples, or even unmarried couples, right? They have to be married. The City of Philadelphia has a policy that prohibits discrimination on the basis of sexual orientation. Litigation ensued, and the Supreme Court ruled that Philadelphia cannot enforce this policy as to Catholic social services. Why exactly? Well, the chief's opinion is typical chief. It's bleh, but there's some good stuff in there, right? There's some very good stuff in there. And one of the things that Robert says is a policy that's pocked with exceptions. There's all these exceptions cannot be deemed compelling, right? It cannot be deemed generally applicable, right? If you give exemptions for one group and another exemption for another group, why can't you give an exemption to the Catholics? So, for example, you can't discriminate at the basis of disability. Okay, that's fine, right? If you have a parent with a severe disability, you may not want to give a adopted child to a parent with paraplegic, right? That might be a good idea. So if you can give exemptions to some but not to others, that's a symbol that it's unconstitutional. That's not generally applicable, so strict scrutiny applies. But Roberts also explained that the compelling interest prong applies in a very unique sense. Roberts says, the question is not whether you have a compelling interest in general, whether you have a compelling interest as applied to this group in particular. And since there are many other groups doing adoption service in Philadelphia, do you really need to punish the Catholics? They've been doing this job for 200-something years. Okay. But the Fulton court did not overrule Smith. And let's talk about Amy for a bit. Right? Justice Barrett, no first name anymore? Okay. Justice Barrett wrote this weird concurrence. And I don't know the word to use, but it's just unusual. She could have said nothing. But the majority doesn't overrule Smith. Gorsuch, Alito, and Thomas overrule Smith. Let's get rid of this thing already. And then Barrett has this sort of weird, 1 or 2 page concurrence that Kavanaugh tagged along with, saying, well, I got some questions.
The first line.
Yeah, Breyer, the first sentence, first paragraph, whatever. And I have some questions about Smith. I don't know what the questions are because it's not very important, but there's some questions, right? How would this apply to a corporation? Smith is, 30-something years old? Your boss wrote it. At some point in your life, maybe it's time to think about Smith, unless you're like Justice Thomas, who's never thought about Roe, right? Allegedly, right? Have you never thought about Smith as a law professor at Notre Dame for 25 years? Just it never occurred to you that there might... Anyway, so I don't think there are 5 votes to rule Smith. I just think they're not going to do it. I think Barrett's worried about sort of opening the door to creating exemptions for everything else. So I think they'll just enforce Smith in a much more flexible sense and say, well, there are exemptions here. This is not generally applicable. Let's go strict scrutiny. So Smith, I don't think they're going to do it. Maybe Howie disagrees with me. I don't know. But I mean, that's more or less where we are, right? In the 60s, we started off with this very big separation of church and state. And the court's gone a full 180 on that one, right? Now we're saying, look, guys, just get over it. If you're offended, too bad. As long as there's no coercion, it's probably okay. Meanwhile, in the 60s, you had this broad strict scrutiny for free exercise claims, right? We're going to do the Sherbert standard. And now we're sort of going back the other direction. We're going, maybe a little bit more scrutiny, but not full strict. And these issues are very much in flux. All right, I am Ryan's schedule. All right, I'm done. That's all I want to say. Thank you so much. I'll turn it over to David for a few minutes. And thank you for your time.